Well, good afternoon, everyone. I hope you've been enjoying this today's conference as much as I have. What just a terrific presentation and discussion. Every one of them has just been riveting and coming from all different angles. So we're learning so much. We're creating new relationships that will be lasting and supportive of NPHI, and I am just thrilled about all of it. Today is just like the other days has been just absolutely fantastic. And we're looking forward to a great afternoon as well. We've got a lot of exciting things to continue here, which we're looking forward to. It's really a very special honor for me today to introduce our next speakers. I can't tell you how much we appreciate the wonderful work from Howard Young. Howard has been one of the most incredibly tremendous supporters of NPHI. He's helped us both individually, many of our programs individually, as well as, of course, the ongoing work for NPHI. He and Morgan Lewis have committed themselves to us and to our mission, and it's so rare to have such tremendous loyalty, tremendous engagement, and support from such an extraordinarily important firm as well. So Howard, before we get started, I just really want to say one more time, thank you so much. As everyone knows, you really need no introduction. Howard is a partner at Morgan Lewis and Bacchius and leads the healthcare practice there, where he brings over 25 years of focused experience on fraud, abuse, regulatory compliance. It has tremendous experience with all aspects of healthcare providers, including large and small hospices, palliative care organizations, home health agencies, hospitals, physician groups, pharmacies, and medical suppliers. In addition, his skill in Washington and understanding the regulatory arena as well as the policy arena is just gives us such an advantage to have that acumen and that years of experience to help guide us as we move forward with our initiatives. So we're thrilled about it. Also with us today is Kathleen Rubinstein, and Kathleen is a senior health advisor and policy analyst at Morgan Lewis as well. She assists healthcare organizations with navigating the uncertainties of the changing policy landscape. In addition, she's the founding editor, I should say, of the firm's Health Law Scan blog, and she's a frequent author of articles and analysis of healthcare issues. She also is an adjunct faculty member at the University of Houston's Masters of Public Administration program, where she's been honored with the Excellence in Teaching Award. So between Kathleen and Howard, we have an extraordinary, second to none regulatory counsel, advisors, and strategists to help us as we move forward the very complicated area of health regulation. So with that, we bring them on to give us a presentation. Thanks again.
Thank you very much, Tom, for that warm introduction, and I really appreciate the opportunity to spend this time with the NPHI members. For those of you who may know me, I'm Howard Young with Morgan Lewis, not clean shaven at this moment for No Shave November. I expect that you may have others around either due to COVID or No Shave November who also bear some stubble these days. Anyway, we've got a lot to cover. I'm going to try to get through these slides quickly, and we'll have time virtually for some Q&A at the end. Next slide, please. So these are the items that we'll cover. I'll also cover some additional very current items, such as the Supreme Court hearing or oral arguments that occurred as of today's date. I'll touch upon that and a few other matters, but we certainly want to give you a sense of what we're seeing in today's time, COVID, in terms of audit activity, what we can expect in the future, including perhaps what we can expect with the new administration. So next slide, please. So this is really just a reminder for all of you. We have prepared in this last year a number of different resources for the members. Some of it is that audit rapid response toolkit, which I know had been distributed last year, but we've updated some other materials in the last year and just wanted to make reference very briefly to those materials. Of course, we will continue to update these materials as time goes by, as we see more audit activity and the like. The other thing I want to touch upon is there is that survey question document out there for members. To the extent you are seeing audits, experiencing audits of any types, we'd like to hear about that through that intake process. So just a reminder for those of you who are experiencing audits, and we're starting to see audits again, we certainly would like to hear more information about your audit activity. Next slide. So probably a good segue into what we are seeing. The government, Medicare in particular, put a hold on audit activity following the initiation of the public health emergency, but officially as of early August, CMS said to its contractors, its audit contractors, you can go ahead once more with your audit activity. So what have we seen? We have seen the SMRC, the Supplemental Medical Review Contractor, Noridian, proceed once again with its audits, either initiating new audits or following through on existing audits that they had, in a sense, put aside for a few months following March, April. Once again, we're seeing long length of stay, GIP as the two focus areas for the SMRC. Although the Targeted Probe and Educate audits are authorized, we haven't seen TPE activity in hospice quite yet, some ADR activity, but we haven't seen the same level of TPE activity that we saw prior to the pandemic. The OIG and its audits, they are proceeding. So we've seen a number of different hospices that have faced these Medicare compliance OIG audits. OIG has not yet published any of the final results of those audits, but that activity is being pursued by the OIG. And we are seeing some very limited UPIC activity. It's not to say that at Morgan Lewis we know all of the activity that's out there. We're only hearing about the activity from certain clients, but we are starting to see some limited activity from the UPIC, the program integrity contractors. So, what do we expect down the line? I'll touch upon this. The Provider Relief Fund, the OIG, is going to be auditing use and accounting associated with the Provider Relief Fund, part of the CARES Act. And obviously brand new as of October 1 is the notice of election addenda and the relatedness issue. Will we see audits anytime soon on those issues? Probably not anytime soon, but future audits, I would expect that would be an issue as well. Next slide, please. I wanted to touch upon some recent activity and harken back to many of our discussions last year around the AseraCare decision, which was in the 11th Circuit. It was a very fine decision in terms of its holding that, at least in the context of False Claims Act investigations and prosecutions, when you've got a reasonable medical opinion of, let's say, a hospice physician, that really isn't the stuff of False Claims Act liability. The decision also gave a very good overview of the Medicare hospice benefit. We've been using the AseraCare decision in virtually all of our appeals. What we have not yet seen, though, is how the Medicare contractors, how OIG, for instance, in its audits, and others are going to take the position that we essentially cull from AseraCare and apply it to their administrative decision. Why haven't we seen that yet? Well, we just haven't seen their decision making. We haven't seen the decisions on our appeals as of yet. But one other very important event I wanted to point out here, while the AseraCare decision is a very favorable decision for the hospice community, there were other False Claims Act decisions, opinions in other circuits. So the U.S. ex rel Druding Aquitom versus Care Alternatives in the Third Circuit, that didn't go the way the 11th Circuit went. As a matter of fact, they came to the conclusion, that Court of Appeals came to the conclusion that a medical opinion might in fact be a false claim in connection with the False Claims Act prosecutions. And they joined the Sixth Circuit and 10th Circuits, creating what's called a split in circuits. So go to the next slide. I'll update you all on what that means. Well, because of this split in circuits, there is the ability to appeal a case, that decision of the the Third Circuit. You could appeal it to the Supreme Court, the U.S. Supreme Court. So that is exactly what's happened. Is the provider and Care Alternatives has asked the Supreme Court through what's called a cert review, asked the Supreme Court to hear this split in circuits. It's not certain that the Supreme Court will accept that case. They very often don't accept cases, even when there is a split in circuits. However, there is some hope that the Supreme Court will accept this case. The Supreme Court is having a case conference a few days on the 20th, and we hope to hear after that case conference if they're accepting this cert petition and the appeal in this Care Alternatives matter. So we should know that soon. Now, there is some possibility that the Supreme Court may just defer its decision on whether to accept that cert petition. So we may not hear for some time yet, but hopefully we would hear soon whether the Supreme Court accepts cert. If that happens, we're not going to hear the actual decision because there needs to be briefing and oral argument and the like. So a decision probably wouldn't occur until the next term of the Supreme Court at the very earliest. One last thing I'll note is if the Supreme Court does accept this case, we will have the ability to file what's called a friend of the court, an amicus brief. Most likely we would join with other organizations that also want their views known to the Supreme Court on this issue. So again, stay tuned on that. But if the Supreme Court accepts this case, most certainly we would seek to submit an amicus brief to the Supreme Court on this issue. Okay, next slide, please. So I wanted to make note of this recent criminal case, not because I think there's going to be a flood of criminal prosecutions involving hospices, certainly not the members of NPHI, but every once in a while we do see criminal prosecution activity in hospice. This was recent in September of 2020. The Department of Justice, working with other law enforcement, did a major what they call takedown of a lot of DME suppliers, home health, some hospice and physicians. And among them was an indictment of a former hospice medical director. This was some time ago, 2014 to 2016, of a smaller hospice in California. The allegation being that this physician knowingly and falsely certified patients as being terminally ill for the hospice benefit. Everyday event where the government brings a criminal case against hospice physicians? No, but it does happen on occasion. It provides yet another black eye, if you will, to the hospice sector. So I just wanted to make note of it that this case is out there. Okay, Svetomir, next slide, please. So this is all going to look very familiar to you. This is a discussion about the hospice LCDs, and certainly aware that the hospice LCDs, when applied as a strict standard by the MACs, And this often is the case. And it's not just the MACs, incidentally. Sometimes we see OIG and its outside reviewers try to apply the LCDs as if they're strict standards and not the guidelines that they're intended to be. They're really intended to be tools to physicians when they're trying to prognosticate as to whether a patient is terminally ill or not. But we all know that oftentimes they're not applied as guidelines or helpful tools, but as these strict standards. We continue to see the application of the LCD guidelines in that manner. So as a consequence, this, of course, remains a significant risk area for hospices if they're not documenting in a way that hews closely to the LCDs. And in many cases, terminally ill patients who are determined to be terminally ill by a physician, may not meet the LCD guidelines. Medicare recognizes that doesn't have to always be the case, that only patients who meet these LCD guidelines are terminally ill. Notwithstanding that they recognize that, and the LCDs themselves recognize it, what do we see? Well, they seem to look past that recognition and apply the LCD guidelines as strict standards. So, whenever you have a patient who doesn't strictly meet the LCD guidelines, and we all know this, the teachings out there are make sure you are documenting what it is about that patient that even if they don't meet the LCD guideline, the applicable guideline, why are they terminally ill? So this is old hat, of course, but the reason I mention this again is, I think this remains ground zero for many of the audits that are out there. And Svetomir, if you can advance to the next slide. This remains a challenge. There are other tools available to clinicians who are in palliative medicine or hospice to help prognosticate. We often reference those other tools when the physicians are relying on them. Are the MACs all that familiar with these other tools on prognostication? Remains to be seen. When we raise these in appeals, again, is it something that is well known to the other contractors? The Quick, for instance, again, remains to be seen. So lots of challenges out there that remain around the LCDs. I think long term, this is my own opinion, it's going to be critical to enlist the hospice and palliative care physicians to advocate on either change to the LCDs or to reinforce that they're not the only tool out there to help prognosticate. Now, one other thing, and I'll just, not that I have any inside information on this, but, with the carve-in that's going to come down the line with the Medicare Advantage plans, query whether they're also going to adopt these LCDs and apply them more as standards versus guidelines that we know they should apply them as. So again, LCDs remain a real challenge area for hospice, and I just wanted to provide some observations perhaps for future consideration. Next slide, please. So one of the big frustrations, we've talked about this in the past, has been where the MACs and others are applying what we call the decline standard or a decline requirement when they're determining if a patient is terminally ill or not, or they're doing an audit, for instance, where there's a ADR or a TP and a denial of hospice benefits. So, we obviously have worked with the members to try to understand how frequently this continues to occur. The decline requirement or rule of thumb, if you will, remains a concern. Next slide, Svetomir, we can talk a little bit about some of the cases that many of you are familiar with. The Jimmo case is one from 2011, which provided a model, if you will, a roadmap for how to perhaps challenge the decline standard, which we believe is unsupported by the law. So how do you challenge this rule of thumb application by CMS and its contractors? Well, sometimes you have to go to court. And in other instances in healthcare and the Medicare benefit, the Jimmo case, they did just that with respect to a a rule of thumb standard that was applied with respect to skilled therapy, for instance, what they call the improvement standard. That was a district court case in Vermont. We also saw more recently a case in Connecticut, filed in Connecticut, involving sort of a rule of thumb denial on the first and second level of appeal, the redetermination and reconsideration, where it seemed those contractors were always denying home health benefits upon appeal. A case, again fashioned as a class action, was brought against the secretary, filed in Connecticut. And so this is just a bit of an update. That case got beyond the motion to dismiss phase. The case settled by the parties in February of 2018. So, why do I mention this? Well, again, to the extent that the members are interested in pursuing a court case, which has many challenges, and I'll talk about those challenges in a moment. But there is that avenue to pursue that court case, because sometimes to get the secretary to really pay attention to the issue, you have to bring litigation against the secretary to make that happen. So these are two examples of when that strategy was successful. Svetomir, if you could turn to the next. But I just want to point out there are, certain challenges. One, you've got to figure out where you're going to bring the case. District of Vermont, the Jimmo case, District of Connecticut were two very, we believe, favorable venues to bring this case. And then you've got to figure out, who are the plaintiffs? Who are going to sue the secretary? Is it going to be individual beneficiaries, individual hospice patients? Will it be providers, the hospices themselves as plaintiffs? Will it be a group or even an association? And the answer to those questions as to who the plaintiffs will be also feeds into some of the other litigation challenges. Svetomir, if you could advance to the next slide, talk a little bit about that. So we've touched upon these challenges in the past. 101 in terms of the government's defense. So Defense 101 will be you can't get to federal court plaintiffs because you haven't exhausted your administrative remedies. You haven't appealed these through the administrative appeals process, for instance. Another challenge is, in order to advance a case against the secretary, we need to amass evidence, right, as to the decline standard and the like, and current evidence. So we've talked a little bit before about how you gather that information. That's why we've put out, again, a tool for the members to report on instances where it's seeing this decline standard applied. That's going to be critical to any successful strategy. Then there are things like litigation costs as well. So the reason I mention these hurdles is, maybe there is a way to engage with the secretary or CMS that's short of litigation. May want to keep litigation strategy in our back pocket, but as was the case in the matter in Connecticut that I referred to a moment ago, that settlement really involved CMS educating its contractors once again on what the home health standard or benefit is all about, and maybe that's what we can shoot for and hope for is, again, CMS educate its contractors as to really what the Medicare hospice benefit is intended to be. Now, that education process, is that going to get you all the way there on denials and audits and the like? Well, can't promise that, but a little bit of education to the contractors could certainly do no harm. So, Svetomir, next slide, please. So I want to shift a little bit and talk about the road ahead. Hopefully it's not going to be have all of these potholes and the like, but we've got obviously a new administration. We've got a continued pandemic. We obviously have a lot of patients who continue to need hospice care. So where does that lead us? Svetomir, if you could advance to the next slide. Thankfully, during the pandemic, we have seen additional flexibility from the secretary, from CMS, and I would continue to expect to see that kind of flexibility. We have telehealth, which I think has worked fairly well in the hospice context. Going to be incumbent upon all of you to document in the plans of care and elsewhere when you're using telehealth and why you're using telehealth as opposed to in-person visits and the like. But again, this is just illustrative of one of the areas of flexibility. And I would expect to see, as long as the pandemic rages on and numbers being what they are, I would expect to see that flexibility continue. However, we are seeing some interest in telehealth being used incorrectly. Some fraud in the telehealth space, not in hospice per se, but other areas. So I think it bears repeating here that it's not to say CMS can't revisit some of these flexibilities and won't revisit these flexibilities, particularly if the pandemic continues on for a number of additional months. They may well decide to revisit some of these flexibilities. So important to stay tuned to what CMS says, not just with respect to the hospice benefit, but others as well, because obviously the flexibilities that are afforded to your physicians, for instance, or hospital partners or home health partners may have an impact on your operations and business as well. Next slide, please. So I want to close with just a few remarks on the new administration and what that's going to mean. Every 4 years, basically, when there's a new administration, if there's a new administration, we get these questions. What does it mean, right? What is it going to mean to the healthcare sector in particular? Well, we know there's going to be, because it's going from a Republican administration to a Democratic administration, there's going to be a tremendous amount of turnover, certainly at the political level, at the career level, staff level. There's going to be some turnover, perhaps not as much. I did hear from a friend who's very, very high up at CMS last night that she tendered her resignation. She's not going to be alone. What does that mean? Does that mean there's going to be real policy change for hospice anytime soon? Probably not. Right? Obviously, major policy change would require legislation. We're perhaps going into a Congress where, the Congress is divided, House controlled by Democrats, maybe Senate controlled by Republicans. We don't know yet. But if that's the case, obviously it goes without saying, legislation is going to have its challenges. All that said, at the level we're often talking about in terms of controlling guidance and the like, I wouldn't expect there to be major change, particularly, again, if the pandemic continues to rage on. We are going to see audits, though. I think even if this is my own prediction, even if the pandemic continues to rage, I don't think the Biden administration is going to come in and say, you know what, we ought to just pause all audit activity. Let the providers focus on providing care, get them through the pandemic, and then we'll come back to audit activity. I could be wrong, but I wouldn't envision that that's likely going to be the position of the Biden administration. I mentioned this before, the provider relief fund audits. Well, the first reports, this is under the CARES Act, the first reports are actually due mid-February, February 15th, I believe. And following that, I would expect the OIG is going to, and they're mandated by the CARES Act to conduct at least some audits. Do I believe it's going to be widespread audits among healthcare providers? No. How many hospices will be targeted? Well, hospices did receive quite a bit of the CARES Act provider relief funding. I do expect some hospices to be audited, but is it going to, sweep across the hospice industry, these OIG audits? No. All that said, you have to be ready, right? You have to have your accounting methodology in accordance with the terms and conditions, your I's dotted and T's crossed in terms of how you're tracking the provider relief funds, whether it's for PPE or other uses associated with the coronavirus. So just make sure you are in preparation mode for what's to come there. And then last thing I want to note is today, as we are recording this, the challenge of the Affordable Care Act was heard in the Supreme Court. It's oral argument this morning. What I heard from a colleague who listened to the oral argument is, from the questions and answers and the like, perhaps not likely the Supreme Court is going to throw the entire Affordable Care Act out the window. They've been asked to do that. Some of the issues, incidentally, is does the states, Texas and the other states that challenged it, do they have standing to bring this case? Can they even bring this case? The individual mandate, those states like Texas and others, the red states, so to speak, are challenging that individual mandate as unconstitutional. Will that stand? Congress had reduced that penalty for essentially not going out and procuring insurance down to $0. So with a $0 penalty, is that a tax? One of the issues that likely will be an issue. And then the big issue perhaps is, if the Supreme Court determines the individual mandate is unconstitutional, does that mean the entire law has to fall? It's referred to as severability. Or can the Supreme Court say, well, that provision is unconstitutional, but we're not going to throw out the entire law. We're going to sever that unconstitutional provision from the rest of the law, which will allow it to stand. So that's to give you a flavor of some of the issues afoot before the Supreme Court. Oral argument was today. As I'm recording this, are we going to hear tomorrow from the Supreme Court? No. Are we going to hear in December from the Supreme Court? No. I think we will hear probably not till June as to what ultimately the Supreme Court decides to do as to that challenge to the Affordable Care Act. So thank you very much for giving me your time. And I know we're going to hold some time for Q&A at the end. Again, very much appreciate giving you all the update. And I'll cede back the rest of my time, Svetomir, to you. Thanks again.
Well, thank you again, Howard and Kathleen, for that really important discussion and presentation. As you all can see, there's so much going on in the regulatory arena. And of course, with a change in administration, so many of these things will be revisited. So being directly engaged and with the support and advocacy of Howard and Kathleen and the team, it's going to be an important time for us to advocate on our behalf, particularly as change is about to occur. So thank you again for your leadership and for your support